Modern families are geographically dispersed. Assets are held in multiple jurisdictions. When a person connected to Vietnam passes away, one critical question arises. How does Vietnamese law treat overseas assets in a cross-border estate? Vietnamese private international law distinguishes between assets located in Vietnam and assets located abroad. Location is not a minor detail, it often determines which legal system governs succession. As a general principle, a movable property is governed by the law of the place where it is situated. If a Vietnamese national owns real estate in another country, succession to that property is typically governed by the law of that foreign country. Vietnamese courts generally do not exercise jurisdiction over a movable property located abroad. For movable assets located overseas, such as foreign bank accounts, securities, or investment portfolios, the analysis becomes more nuanced. Nationality, habitual residence, and governing law clauses in a will may influence the applicable law. Each factor must be examined carefully. In certain circumstances, succession to movable assets may in certain cases be determined by the law of the deceased's nationality at the time of death. However, enforcement of those rights over overseas assets depends on foreign recognition. Vietnamese law alone cannot compel foreign authorities. Even if Vietnamese inheritance law applies conceptually to part of the estate, Vietnamese courts cannot directly transfer foreign assets. Enforcement requires cooperation with foreign courts or administrative bodies. Jurisdictional reality limits domestic reach. Vietnamese forced heirship rules protect certain compulsory heirs. Whether these protections extend to overseas assets depends on conflict of law principles and recognition by foreign jurisdictions. Application is not automatic across borders. In cross-border estates, probate often occurs simultaneously in Vietnam and abroad. Vietnamese courts may address domestic assets. Foreign courts administer overseas property. Coordination is critical to avoid inconsistency. If a foreign court determines distribution of overseas assets, Vietnamese courts may consider that decision for domestic purposes. However, recognition of foreign judgments in Vietnam follows separate procedural rules. Reciprocity and public policy remain relevant. Foreign financial institutions generally require compliance with local probate procedures. A Vietnamese inheritance decision alone may not release funds. Heirs must satisfy foreign documentation and recognition requirements. Shares in foreign companies are governed by the corporate and inheritance laws of the jurisdiction of incorporation. Vietnamese law may recognize heirship status, but cannot directly alter foreign shareholder registers. Enforcement depends on foreign legal process. Where the deceased held both Vietnamese and foreign nationality, cross-border conflict of law analysis becomes more complex. Different jurisdictions may assert authority based on nationality or domicile. Structured planning reduces friction. Overseas assets may be subject to foreign inheritance or estate taxes. Simultaneously, Vietnamese tax reporting obligations may arise. Integrated tax planning is essential in multinational estates. A will may include a clause selecting a particular governing law. Such clauses may influence distribution of movable assets. However, foreign authorities will ultimately apply their own conflict of law rules. For individuals with significant assets, both in Vietnam and abroad, separate wills may enhance clarity. Each will addresses assets within its respective jurisdiction. Coordination prevents unintended revocation or contradiction. Vietnamese court judgments regarding inheritance cannot compel foreign land registries or banks to transfer assets. Mutual recognition or separate foreign proceedings are required. Jurisdictional sovereignty remains decisive. If estate planning is fragmented, different courts may reach different conclusions regarding asset distribution. Inconsistent judgments create enforcement challenges. Coordinated structure mitigates this risk. If you have assets in multiple jurisdictions, do not assume that one legal system will control the entire estate. Vietnamese law treats overseas assets through the lens of conflict of law principles, but practical enforcement depends on foreign cooperation. Cross-border estate planning should begin with a full asset inventory. Then determine governing law for each asset class, align wills and succession documents accordingly. Vietnamese law may recognize heirship rights in cross-border estates, but overseas assets are primarily governed and enforced by the law of their location. For multinational families, effective estate planning means respecting jurisdictional boundaries, while coordinating legal systems deliberately. Without that coordination, complexity becomes conflict. If your estate includes assets both in Vietnam and overseas, do not assume that one legal system will control everything. Governing law, jurisdiction, recognition, and enforcement are separate legal layers, and each must be addressed deliberately. To structure your cross-border estate plan with clarity and legal precision, contact LTS Law at lts.com.vn for coordinated international guidance. In multinational estates, alignment between jurisdictions is not optional, it is strategic.